The paperwork arrived in a folder. Maybe it came from the hospital social worker, maybe from the nursing home admissions coordinator, maybe from the discharge planner who explained the timeline. The folder had a list of documents to gather, a cover sheet with instructions, and an implicit message that if you collected everything on the list and submitted it, the process would move forward. What the folder did not contain was any explanation of what a Medicaid caseworker is actually trained to find. Experienced elder law practitioners consistently report that the majority of nursing home Medicaid applications are denied the first time they are submitted. Not because the applicant is ineligible, because the documentation is incomplete, or because a financial transaction somewhere inside the past 60 months triggers a review that the family did not know was coming and did not prepare for. The 80% figure cited by Medicaid planning specialists reflects a well-documented pattern, even where national aggregate data remains incomplete, because the underlying causes are the same everywhere. An audit framework that catches unprepared families. The system is not designed around helping families access benefits they are legally entitled to. It is designed around a federal audit framework that calculates ineligibility by formula, applies penalty periods by formula, and extends the time a family pays full private pay nursing home costs by the exact number of months that formula produces. By the end of this video, you will know the one document that determines whether a Medicaid application is approved, denied, or approved with a penalty period attached. Most families never hear the name of this document before their first application is rejected. The starting point for understanding how any of this works is a federal statute. Title 42, United States Code, Section 1396P, subsection C, passed by Congress and sitting in the federal code at the offices of the Office of the Law Revision Council on Capitol Hill in Washington, requires every state Medicaid agency in the country to look backwards 60 months from the date of application. Not 12 months, not 24, 60 months. 5 years of financial history, covering every bank account the applicant owned, every asset transfer they made, every gift they gave, every property transaction they completed. That 60-month window is called the look-back period, and it is the framework inside which every Medicaid application for long-term care is reviewed. The mechanism works like this. A Medicaid caseworker at the state agency, working from the documentation the family submits, identifies every transfer of assets made for less than fair market value during the look-back period. When a disqualifying transfer is found, the caseworker divides the total transferred amount by the average monthly private pay nursing home cost in that state. The result is the penalty period, stated in months, during which Medicaid pays nothing. In a state where the average private pay nursing home rate is $10,000 a month, a $50,000 transfer produces a 5-month penalty period. 5 months during which the nursing home continues to bill at its full private pay rate. 5 months the family pays out of pocket for care they expected Medicaid to cover. The Genworth and CareScout 2024 Cost of Care Survey, conducted across more than 15,000 providers nationwide and published out of Richmond, Virginia, documents the national annual median cost for a private nursing home room at $127,750, which translates to approximately $10,646 per month. A 3-month penalty period at that rate produces $31,938 in out-of-pocket costs the family was not expecting. A 6-month penalty period produces $63,876. These are not edge cases. They are the arithmetic outcome of transactions that millions of families make every year without any awareness that those transactions are being logged inside a federal eligibility calculation. The part of this that most families miss is not that the look-back period exists. It is that the transactions it flags are ordinary. They are the kinds of financial moves families make for completely logical reasons, with no knowledge that a 5-year audit clock is running. A name added to a bank account, a gift to a grandchild, a life insurance policy held past a certain value threshold. None of these transactions feel like Medicaid disqualifiers when they happen. Every one of them can generate a penalty period when the application is filed. Here's what the caseworker is trained to flag. A bank account with a co-owner's name added within 60 months is treated as a transfer of the co-owner's proportional share. Gifts to grandchildren within 60 months, including cash paid directly to a grandchild rather than to their institution, are treated as disqualifying transfers. Whole life insurance policies whose total face value exceeds $1,500 have their cash surrender value counted as a countable asset in most states and can require assignment or spend down as a condition of eligibility. IRA and 401k assets are treated as countable assets for the applicant in most states, with the community spouse's retirement assets handled under a separate calculation. Missing documentation for transactions that occurred more than 2 years ago, bank statements and gift records that families no longer have, can produce a denial based on incompleteness alone, even when the underlying transactions were fully legal. The family home is not a countable asset during the applicant's lifetime under specific qualifying conditions, but it becomes subject to Medicaid estate recovery after death in all 50 states. The federal government ran the math. They calculated a formula that converts every prior asset transfer into a calculable ineligibility period. They applied that formula in all 50 states simultaneously. They wrote it into statute, and they left families to navigate it through a folder from a hospital social worker. The denial itself is not the end of the damage. When an application is denied, or when a penalty period is applied, the nursing home continues to bill at full private pay rates. If the family cannot cover the gap between what they have and what the facility costs, the nursing home may begin discharge proceedings. A discharge during a pending Medicaid application or during a penalty period is legally permissible when the resident cannot pay and Medicaid has not yet activated coverage. The combination of an improper application and a discharge notice is the most financially destructive outcome in the entire elder care system, and the families it happens to almost never saw it coming from the folder they received at the hospital. Before we get into why this system produces these outcomes by design rather than by accident, if someone in your family is navigating any of this right now, consider subscribing. This channel publishes investigations like this regularly, and the next one covers something that affects an even larger number of families than what we have covered today. The deeper you go into how the Medicaid Look-Back Review actually works, the more one pattern becomes impossible to ignore. The complexity is not incidental to the system. The documentation requirements, the 60-month window, the penalty period formula, the state-by-state variation in countable asset definitions, the Medicaid Estate Recovery Program that operates after the applicant dies. All of it exists as a coordinated federal and state framework that functions exactly as designed, which is to say, it functions as a screening mechanism that rewards families who engage professional help before filing and penalizes families who received a folder and assumed the folder was the guide. The Medicaid and CHIP Payment and Access Commission, a nonpartisan legislative branch agency based in Washington, D.C., has documented in multiple reports the gap between Medicaid long-term care eligibility and the families who successfully access it. That gap is not primarily a gap in eligibility. It is a gap in documentation completeness and pre-filing preparation. The families who are denied were, in most cases, legally entitled to the benefit. What they lacked was the document that determines everything. That document is the Comprehensive Financial Inventory. It is not a form issued by any government agency. It is not included in the folder from the hospital. It is a complete accounting, prepared before the application is filed, covering 60 months of all accounts, all transfers, all gifts, all beneficiary designations, and all asset ownership changes across every financial instrument the applicant held or contributed to. The Comprehensive Financial Inventory is what a Medicaid caseworker constructs from whatever the family submits. The difference between a family that passes the review and a family that receives a penalty period is almost always whether someone constructed that inventory intentionally before submission and corrected it versus whether the caseworker constructed it for them from partial documentation and found the problems first. What this data actually shows, when you look at it carefully, is not that the families being denied are ineligible. It is that the review process is structured to find disqualifying transactions in documentation that was not prepared with the review in mind. And that means the denial rate is not a measure of ineligibility, it is a measure of preparation. The proof point from the beginning of this video is the pattern that practitioners across this industry have documented in state after state. Most first submission denials involve applicants who were legally eligible. The The document that would have changed the outcome existed as a concept. No one put a name to it before the folder arrived. Everything before this point is what the Medicaid system counts on families not knowing before the application is filed. What follows is what changes the outcome. The one document that determines everything is the comprehensive financial inventory, and the way to build it is not to wait until the application is due. Begin gathering bank statements now for every account: checking, savings, money market, certificates of deposit, and brokerage, covering the full 60 months prior to any anticipated application date. Add to that file all annuity contracts, all life insurance policies with their face values and any current cash surrender values, all real estate deeds and any property transaction records from the past 5 years, and written records of every gift or transfer of more than $500 made during that window. This is not a Medicaid form. It is your pre-review inventory. Building it before a caseworker sees it is the difference between identifying the problems and being informed of them. First, complete the American Council on Aging's free Medicaid eligibility pre-screener available through Medicaid Planning Assistance before submitting any application. It is a state-by-state tool that identifies likely disqualifying issues before the formal caseworker review begins. It costs nothing. It takes approximately 30 to 45 minutes. It does not substitute for professional review, but it surfaces the categories of transactions most likely to trigger a penalty calculation in your specific state. Second, if any transfer, gift, or co-ownership change occurred in the past 5 years, consult a certified elder law attorney before filing. The National Academy of Elder Law Attorneys, headquartered in Vienna, Virginia, maintains a directory of certified attorneys by state at its website. A consultation typically costs between $200 and $500. 1 month of private paid nursing home cost at the national median rate is $10,646. The consultation cost is between 2 and 5% of one penalty month. It prevents penalty periods that can run 3 to 6 months or longer on modest estate transfers that no one flagged at the time they were made. Third, if the application is denied, request the denial letter in writing with the specific reason for denial stated explicitly. Appeals must typically be filed within 30 to 90 days, depending on your state, and the denial letter will specify the deadline. The right to a fair hearing exists in every state. Your state Medicaid agency is required to tell you how to access it. Do not assume a denial is final. The rate at which denials are reversed when properly appealed is substantial, and practitioners report that many states reverse denials before a hearing ever takes place once a formal appeal is filed. Fourth, if you are receiving a discharge notice from a nursing home during a pending Medicaid application, contact your state long-term care ombudsman immediately. The Long-Term Care Ombudsman Program, established under the Older Americans Act and operating in every state with its national program office in Washington, D.C., has the authority to intervene in discharge proceedings. A nursing home has limited legal grounds to discharge a resident with a pending Medicaid application. The Ombudsman can stop a discharge that is proceeding on legally insufficient grounds. The total time investment for the complete protocol is approximately 3 to 5 hours of document gathering plus 1 professional consultation. The average cost of not completing it for a family with a single undocumented transfer in the look-back window is between $31,000 and $63,000 in avoidable private pay costs during a penalty period that need not have been triggered. Before this video, you were the family the Medicaid application process was designed to catch unprepared. The family that received a folder, assumed the folder was the guide, and did not know what a caseworker was trained to find until the denial letter arrived. You are now the family who knows that the comprehensive financial inventory exists, that it must be built before submission rather than discovered through the caseworker's review, and that the penalty period is calculable, avoidable, and in most cases, the direct result of a gap in preparation rather than a gap in eligibility. If you are currently navigating any of this and something in this video matched a situation you are dealing with right now, share it in the comments, because you are not the only one and your experience is evidence. Share this with anyone in your family who is dealing with any of this. And if you want to stay ahead of the industry rather than behind it, subscribe. The next one is something most families find out too late.